Welcome to Second Take, the show that focuses on the issues behind the news. The court review of the Department of Mineral Resources' controversial award of prospecting rights at the Sishen iron ore mine to Imperial Crown Trading took place this week. Terence Creamer joins me to discuss developments in the North Gauteng High Court. Terence, can you provide us with some background on how this review arose and what the applicants were seeking?
Yes, it really arose because of the decision by the Department of Mineral Resources last year to grant a prospecting right to Imperial Crown Trading 289, a very little known company at the time, at the Sishen iron ore mine, which is a mine that's really been operational for many years. It was an ISCOR mine back in the 1960s, I think it started. So it led to firstly, an outcry from ArcelorMittal, who felt they were the original owners of this 21.4% stake, as well as a Sishen Iron Ore Company, which is owned by Kumba, which in turn is owned by Anglo-American. So you can see there's a lot of international interest because these are international companies, Mittal and Anglo-American, in this matter. And basically, it arose because there was a feeling that ArcelorMittal should have converted their 21.4% right at that mine. And when they didn't do that, that right became vacant. And there were two applicants for that right. One was Sishen Iron Ore Company and the other was Imperial Crown Trading. And in the end, the decision by the DMR was to grant Imperial Crown Trading the prospecting right over this operation. Now, Sishen is the applicant in this matter and raised a concern about the fact that the RCT was given this right because they felt that they had prepared their documentation competently, and in terms of the MPRDA, the Mineral Petroleum Resources Development Act, they felt that the way that they had prepared that application was it really should have been converted in their favour. Instead, the government had decided to give it to this little known company, and we subsequently learned quite politically connected company called RCT. So they're looking to overturn that decision in the North Gauteng High Court in front of Justice Raymond Zondo. And the hearing, well, there have been many papers and written arguments have been submitted for this review, but the actual hearing took place in the court this week. And Justice Zondo had to listen to these oral arguments over the last 4 days. And the matter concluded, the oral argument concluded on Thursday. So the applicant really wants this overturned. They were joined in this application by Mittal, who feels that also that the state should not have granted RCT this prospecting right. But they are seeking a different outcome. So Sishen is saying only 78.6% of this mineral right was converted by us in 2008, and the Mittal right therefore became vacant, and therefore we applied for it and should have received it in terms of our competent application. And they raise a lot of problems with the RCT application, the lack of competence, and also fraud and manipulation of documentation within that. Mittal, on the other hand, is saying this is an undivided right and there's no such thing as a fractionalization of rights under the MPRDA. And therefore, actually, when the conversion was made in 2008 to SIOC, or the Sishen Iron Ore Company, SIOC got 100% of that right, and they have a 21.4% interest in that undivided right. And therefore, they did not apply, they did not need to apply because that right was already converted and they have an interest within that right. So they tried to make a big distinction between rights and interests, and so both are seeking to overturn it, but both are seeking very different remedies.
How did the DMR and ICT respond to these allegations?
Well, the DMR, the state, who had to respond to SIOC's allegations that RCT's application was incompetent and therefore shouldn't have been considered, went to some lengths to explain why they accepted the RCT application, although they didn't at all respond, it seems, to the allegations of fraud and manipulation of the documents. So there's the documents that were submitted as part of the RCT application were submitted over a long weekend on the long weekend of 2009. So the Act said you had to convert by May the 1st, 2009. May 1st fell on a Friday, and therefore the first business day was the 4th of May 2009. And during that period, Sishen Iron Ore Company claims that their documents were photocopied and put in as part of the RCT application. So not the full document, there was an aspect, the title deeds, which is part of a mineral rights application, needs to be part of that, certified copies of title deeds. They claim that because RCT was doing this in haste, they got people within the department and manipulated their contacts with it to get access to their document, their title deeds, amateurishly photocopy them, trying to hide the certification stamps, and then submit it as part of their document. So they claim it was fraud, it was a copy of their own documents, that these were manipulated documents, and therefore on that ground alone, DMR should have just rejected the RCT application. But they have a number of other grounds on why the application was incompetent, and also why the Department of Mineral Resources had acted in an unorthodox, and they feel also illegally, in the way they had applied their mind to the merits of the applications, because the application by SIOC was meticulously prepared, and it really, I mean, in terms of the MPRDA, seemed to tick all the boxes. But government, are they saying that the RCT application wasn't as meticulously prepared, and therefore didn't meet the competence that was required of it, and therefore should have never been considered. But in the end, government did consider the RCT application and did grant the prospecting right. And the government is saying they did that because they felt that many of the issues raised by SIOC were immaterial, that they weren't, key to the application by RCT, and then RCT wanted its peers on better credentials with regard to BEE, or historically disadvantaged persons. But again, SIOC has some arguments, 6 shareholders, 6 black shareholders, yes, owned and managed by black individuals. But is that really what the Act was talking about in terms of empowerment and broad-based empowerment, when you have a company like Kumba and SIOC, which has employee share ownership schemes and a much more broader base of people that can benefit from their mining activities. So you can see it's a complex matter, and RCT, on the other hand, responded by saying, well, factually you're incorrect, SIOC, we never copied your documentation. In fact, you sent an agent into the DMR because we know you have people that you are close to in the DMR, because you also manipulated your dates in the way you applied for your application. And you sent an agent to amateurishly copy this and then insert it into our documentation in order to discredit our application, which was a defense on the facts. And then DMR's other argument was that, well, they threw in the fact that this manipulation of the dates by SIOC, and saying, yes, well, that's also going to be an issue that makes for your documentation to be considered incompetent, and we plan to be laying criminal charges against Kumba and SIOC in the next week or so. So you can see there's a lot of issues that have come through. Those are the sort of responses. The state feels that the RCT application was competent and they could consider it, and they did grant it, and they felt that if they were to interrogate SIOC's applications, there's also some manipulation of department officials and of the Act. And the judge has to apply his mind to both those sides of the argument.
Now that the review has been concluded, what can we expect next?
Well, the first thing we can expect is that the judge is going to have to take some time to apply his mind to a very complex case, which is complex on the law, because both Kumba, SIOC's and ArcelorMittal's cases are very much about how this law of administrative justice case should have unfolded, and how mineral rights should be perceived. What is an undivided mineral right? Can you fractionalize rights? Was it necessary for Mittal to really convert? Was the 2008 grant to SIOC not for the whole undivided right? And they said, that we would have objected to that expropriation of our 21.4% right, but we weren't really prejudiced in any way. So we therefore didn't object, because we had a long-term agreement to get iron ore at cost plus 3%, which is a big advantage to Mittal. So there's these very detailed technical legal arguments about what the Act says, what mineral right conversion involves in South Africa and should involve in a mine like this. And then there's the issue that's the more sordid details of the case, which really relate not so much to the mineral law, but to the facts of how this administrative justice was either done fairly or was actually done incorrectly by the DMR. So there's a lot to consider. I mean, we had a seriously heavyweight legal teams. I mean, SIOC alone had 6 senior counsel there, 6 silks. I think there were no less than 2 for every other of the respondents and the applicants. These are very serious senior legal people. They were all briefed by very well-established attorneys. So, Judge Raymond Zondo has got a lot of documentation to consider. He has to also consider the oral evidence. And he said, you can't expect this judgment or my decision within the next week. It's going to take me some time. So we can expect some time. In the meantime, there'll be some other noise around this case because it looks like legal criminal charges will be laid by government against SIOC in the next week or the next few weeks, and that will add some new noise. Plus, there's also the criminal charges that have been laid by SIOC against ICT and the state. And we've already seen a few weeks ago the Hawks raided the DMR, the Hawks raided ICT's offices, and they also raided for the first time, I think, in South Africa's history, the State Attorney's Office. So they are already looking and probing whether there is a criminal case here. So that you can see there's a long way to run. This is the civil matter. The civil matter, there will be a judgment from Judge Zondo in the coming months. There's likely to be appeals to that. So we've got some way to go. Then there's the criminal thing that might come to court at some point. And then over and above that, there's the supply agreement between Mittal and SIOC, which is the subject of an arbitration. That arbitration is going to be heard in May next year. Now, whether all the legal loose ends are tied up by then, which will make the arbitrators' decisions easier. For instance, is Mittal right on that you can't have fractionalization of rights, or is SIOC right that there were 2 distinct rights that had to be converted? Which of those 2 legally is correct, which Judge Zondo will sort of pronounce on, but there could be appeals. That also has to be heard. So in the meantime, we've got a lot of noise, a lot of time that's going to have to pass, but still a lot of other legal and quasi-legal processes that have to go ahead. So there's a long way to go with this story, and I think many column centimeters are still going to be written.
Well, thank you for shedding some light. That's the show for today. Join us again next time for more news and insight into what's happening in the mining world.